The present patent system is a crony socialist cesspool. How to fix it? Presidents Clinton, Bush II, and Obama systematically destroyed the patent system to create the present cesspool that benefits large DEI companies and stifles startups. A quick review of the history of the patent laws shows that Ronald Reagan, as part of his economic revival program, strengthened the patent system after years of neglect and attacks by socialists who had basically neutered the patent system. One of the things that Ronald Reagan did was to create the Court of Appeals for the Federal Circuit in 1982. This court was assigned to hear all patent appeals because there was an absurd inconsistency between the different circuits on patent cases. The first CAFC panel had about half the judges were patent attorneys. Reagan also helped pass a number of other laws to strengthen patents. Then President Clinton, without any authorization and against the law and our Constitution, gave away all our patent applications to the Japanese and spent most of his presidency trying to destroy the patent system. Just as he was leaving office, he passed the Intellectual Property and Communications Omnibus Reform Act of 1999. This weakened the right of inventors by requiring the publication of most patent applications 18 months after they were filed. This is a clear violation of the social contract with inventors. That social contract is that inventors give up their right to keep their invention a trade secret, and in return for which they get a limited term property right. Now inventors had to disclose their inventions to the whole world, regardless of whether they obtained a property right. It's a clear violation of the social contract and destroys the meaning and the value of obtaining a patent. But this is exactly what the large crony socialist companies wanted. Bush II continued this trend of destroying the patent system. He did it mainly by destroying the patent office. He did it through the likes of John Dudas and John Dahl, who systematically changed the patent law at the patent office without any authorization, without any comment, unconstitutionally, suggesting that our patent system was not as rigorous as Europe's. They said this after the 1990s, when the U.S. created the internet and there was an explosion of technology in the U.S., and yet somehow our patent system was not keeping up with the Luddites in Europe. These two people should be prosecuted for treason. They clearly gave aid and comfort to the enemy. Obama managed to put the final nail in the coffin of the patent system when he passed the Orwellian named America Invents Act. You can see with these three presidents that our patent system has been turned into a crony socialist system, just like we see that the CDC and the FDA have been regulatorily captured, and that they tried to kill us all during COVID. This law, the America Invents Act, is an Orwellian study in crony socialist legislation. It changed the law from first to invent to first to file. This is a clear violation of the Constitution. The definition of an inventor is not the first person to file a patent. It rendered the 1-year grace period to file a patent application, which had been in place since 1836, meaningless. It added 2 more post-grant review processes, which means that there's always a cloud hanging over the title of your invention. It included a giveaway to Wall Street, which was called the business method exception, which gives a whole separate review process for business method patents. There is no such thing as a business method patent. This is clearly just Wall Street demanding that they get special privileges. Wall Street would have labeled Bitcoin a business method. This just shows how absurd this attitude is. Clearly, Bitcoin is built on technology and solves some very important technological problems. But Wall Street didn't want to have to compete with technologists, so they got this absurd provision passed. The law also eliminated patents that involved tax strategies. First of all, of course, we shouldn't have these absurd tax laws. But if we do, then if there's technologies that people can create to avoid these absurd taxes, then those are definitely patentable. And there was a special provision for a law firm that got them out of a $200 million malpractice lawsuit, and it provided a patent term extension for the drug Angiomax. This pork-laden piece of shit destroyed patent law. So if this law was so clearly pork-laden and unconstitutional, why did our so-called representatives vote for it? Well, they voted for it to help their crony socialist friends, and because they assumed that no one was paying attention. And of course, they were right. This is exactly how our supposed government works today. I've just made an excellent case that the Patent Office, the patent laws, and the courts have no idea what they're doing with respect to patent law. Perhaps we should eliminate the whole thing. But that would be throwing the baby out with the bathwater as the nicest interpretation. Economist Hernando de Soto talked about the importance of property rights to the economy and how all sorts of countries have a dysfunctional property rights system. De Soto's solution wasn't to eliminate property rights for land, businesses, and houses, but to implement a proper property rights system. That's exactly what I'm going to explain going forward, how to develop a proper patent system. Obviously, this is a huge subject, so this is just an outline of the major points. We should also note that eliminating the patent system is by definition unconstitutional, so we'd have to get around that issue. In addition, property rights for inventors or inventions is a straightforward application of Locke's natural rights, which is the basis of the founding of the United States of America. The first step in reforming or creating a proper patent system is to understand what an invention is. All human creations can be categorized into two groups, those with an objective result and those with a subjective result. Since objective and subjective are opposites of each other, they include the universe of all human creations by the law of the excluded middle. Those human creations with an objective result are inventions. Those human creations with a subjective result are art. We also need to define what the proper definition of an inventor is. An inventor is the first person to create an invention. It's not the first person to file a patent application or any of this other nonsense. The next thing that is fundamental to understand is that all inventions are made up of existing things and made up of existing knowledge. You can't create something from nothing because of the law of conservation of matter and energy. As a result, all inventions must be a combination of existing or known elements. With that background, I think probably perhaps the most consistent patent law that's been created was the U.S. Patent Act of 1836, with a close second being the Venice Patent Statute of 1474. The Patent Act of 1836 created the Patent Office, and therefore the examination of patents. It stated that any person or persons having discovered or invented any new and useful art, machine, manufacture, or composition of matter not known by others or used by others before his or their discovery of the invention can apply for a patent or exclusive property in their invention. The Patent Act of 1836 also included the requirement that you provide a model. While this resulted in some beautiful models, I think that in a number of cases, this is both impractical and too high of a burden. When looking over the Patent Act of 1836, it's amazing just how comprehensive it is and how well laid out it is. Some of the changes that I would suggest would include increasing the certainty of the property right involved in a patent. There's something called fraud on the Patent Office, which is where you fail to disclose how to make an invention, or you fail to disclose prior art, that is, previous inventions or technology. The problem with this is it's supposed to be fraud, so there's supposed to be a higher standard required. that is, clear and convincing evidence. But because these cases are tried in front of ordinary people as jurors, unfamiliar with technology, they're easily swayed by emotion. This has become a dangerous precedent that has caused unintended consequences. It meant that patent attorneys would often tell their inventors to not do their own prior art search, which defeats one of the major goals of the patent system. The major goal of patents is to increase the diffusion of knowledge. If this rule undermines the diffusion of knowledge, it defeats one of the purposes of the patent system. One solution for this would be to have a special court, much like we have tax courts, that only determines what the patent covers and whether a product infringes the patent. It doesn't determine damages. This could be run by the patent office, by people who are skilled in the art of writing and understanding patent claims. Along this line, I would eliminate maintenance fees, which were not part of the Patent Act of 1836. Maintenance fees or annuities are an additional tax to keep your patent valid. This is just another got you to undermine the rights of inventors, particularly small inventors. The whole point of the government is to protect the rights of people. This is just an arbitrary fee that is necessary to be paid to the government to do the job that we're already supposedly paying for it to do. I also think that the term of patents should be roughly the length of time that the average person would live from the time the patent is issued. I think that this should be the same as copyrights. Copyrights today now can go on almost forever. That is, the life of the author plus 70 years. I think a good compromise would be about 30 years from the date of issuance, not the date of filing. Almost from the very beginning, the Supreme Court has screwed up patent law by sticking their noses in and not following the law. This is not surprising, since most Supreme Court justices' undergraduate degrees are in history, political science, English, or something like that. They have no idea and no understanding of technology. They've never developed or invented anything except stupid legal theories. These complete idiots think that they're better prepared to make a judgment than the people who have a technical background. As you can see, I'm absolutely disgusted with the Supreme Court, and this goes all the way back to the case of Hotchkiss versus Greenwood in 1851. Which set patent law off on an irrational standard. This irrational standard is called the non-obvious requirement, or the inventive step requirement in the rest of the world outside of the US. No such standard existed in the law or in the statutes, but these geniuses thought they knew better. Why do I say this is so irrational? Well, there's a novelty requirement in patents, which means that something has to be new. As I explained earlier, new means a new combination that by definition is made up of things that already exist. It's called conservation of matter. New here cannot mean there's something that never existed before. The components have to have existed before. That's required for another part of the patent. In order to describe something so that someone can build it, they have to understand the language, which means that it has to be made of things that exist. But these geniuses added a new requirement called non-obviousness. How can something that is new be obvious? That is just absurd. This is a non-objective standard, whether it's called non-obviousness or an inventive step. This is just an excuse for the courts and other people to shoot down valid patents and inventions. If you remember, the definition of an invention is a human creation that has an objective result. It's got nothing to do with a non-obviousness step or an inventive step. How do I know this is absurd? Because the court's own reasoning for shooting down this patent was that these components, the knob, the metal shank, and the spindle and the dove, were not new. All were well known and in common use. Well, duh, of course they were well known. That's required in order to explain to someone how to build something that they can use themselves. I think the case of Eli Whitney's cotton gin illustrates this very well. Once Eli Whitney solved the problem, his invention was so simple that people made it without hardly any technology at all. The cotton gin was a combination of a wire screen and small wire hooks to pull the cotton through, while brushes continuously removed the loose cotton lint to prevent jams. Many simple seed removing devices had been invented before, but until the invention of the cotton gin, most required significant operator intervention and worked only at small scale. So revolutionary and so powerful was the cotton gin that it made people 50 times more productive in separating the cotton from the seeds. And this step was the main limiting factor in the production of cotton. Without a cotton gin, it took a person 10 hours to produce 1 pound of cotton. With a cotton gin, they could produce 5 pounds per hour or 50 pounds in 10 hours. In a decade after the invention of the cotton gin, the United States increased its output of cotton by 40-fold. Even if Eli Whitney had charged an exorbitant price for this cotton gin, the 50-fold increase would have meant that plantation owners would have made their money back in almost no time. Clearly, Eli Whitney was screwed out of a huge fortune. Imagine if he kept the cotton gin a trade secret and just processed cotton for other people. He would have made a fortune, but this would not have been nearly as efficient for the economy as a whole. But yet there are idiots out there like Austrian economists who suggest that Eli Whitney was not a benefactor to mankind. They argue that he was an evil, rent-seeking monopolist. Insane. Because of this stupidity by the Supreme Court, I would throw away all patent jurisprudence since 1851 as irrelevant or wrong. I will interject that the CAFC, that is, the Court of Appeals for the Federal Circuit, after Reagan started court, tried to put rational standards in place given this irrational requirement. But again, the idiots on the Supreme Court screwed this up. But that's not good enough. It should all be thrown out. Also, there's a lot of people who think that novelty is not enough for a patent, because they think, oh well, you could just paint it blue or add some other irrelevant detail. An invention has an objective result. Painting it blue doesn't change its objective result. For instance, painting the cotton gin blue does not provide a new result. Therefore, it's not part of the invention. So that's just a straw man argument. I want to point out that Ayn Rand also dealt with this nonsense that every invention is a combination of existing things in her novel Atlas Shrugged. This scene comes from a discussion about Reardon metal, and it's between James Taggart and his wife Cheryl. James says he didn't invent smelting and chemistry and air compression. He couldn't have invented his metal, but for thousands and thousands of other people. His metal. Why does he think it's his? Why does he think it's his invention? Everybody uses the work of everybody else. Nobody ever invents anything. Cheryl replies, puzzled, but the iron ore and all those other things were there all the time. Why didn't anybody else make that metal? But Mr. Reardon did. This shows the parasitic, lazy attitude of socialists who say that nobody does anything. It's always a group effort. It takes a village. Bullshit. So we've seen that, in fact, because of the conservation of matter and energy, there's no way to create something that isn't made of existing elements. I've pointed out that even if this was possible, you would be violating the requirement to describe the invention in enough detail that one skilled in the art could build it. So this is the most absurd oxymoronic argument ever. Some other points that need to be made in order to create a proper patent system include repealing the antitrust laws. Antitrust laws are not law. They're politics masquerading as law. They are a clear violation of the freedom of association. Therefore, they're a violation of natural rights that were pushed by socialists to attack capitalism. As many people have pointed out, the antitrust laws boil down to, if you charge the same price as somebody else, you're colluding with them. If you charge more than them, you have monopoly power. If you charge less than them, then you're trying to undercut them and create a monopoly. This is insanity. This is not law. The only valid question when applied to competition and competitors in the market is, are they violating the law, that is, someone's natural rights, and do they have special privileges granted to them by the government? By the way, socialists never complain about these special privileges, but they do complain about companies that have continuously invented and improved their products, lowered their costs and prices to dominate a market. Going hand in hand with this is the stupid idea of perfect competition in economics, which is just a recipe for poverty and disaster, and it's the basis of antitrust law. This should be thrown on the scrap heap of history. I did a whole video on this. There are a bunch of economic idiots who think perfect competition is what capitalism is all about. It's not at all what capitalism is about. Capitalism is about protecting natural rights. It's about creating and inventing. It's about using your mind. Perfect competition is the definition of not being able to use your mind. Not being able to do anything to make a better product, because that might give you a competitive advantage. In fact, that this idea is still pushed by economists, just outrageously absurd. Another stupid idea in economics, which was created by a socialist but has been pushed by so-called Austrian economists, is the idea that rivalrous goods are the basis of property rights. Rivalrous is not the basis of property rights and has never been the basis of property rights. I also did a video on this. The basis of property rights is the simple moral principle that if you create something, then you're the owner of it. This rivalrousness nonsense basically comes down to a utilitarian argument. It says that the purpose of private property privileges is to distribute scarce resources, which is just insane. Well, if I come up with a better way of distributing scarce resources, then I can take your land, your house, your property, your business. That is communist through and through. It's communist thinking at its very core. It's also utilitarianism, which is the ethical system of socialism. Another stupid thing that has to be eliminated is this attack on so-called patent pools. Patent pools can be understood by looking at the sewing machine wars of the 1800s. There were a number of inventions that were required to make a modern sewing machine. As a result, since different companies had different patents, they were all trying to create something that the customer wanted, and they were spending lots of money suing each other, arguing that they were violating each other's patent rights. They created their own free market solution, and they agreed to pool their patents and then to pay each other royalties based on how much their particular product used these patents. This solved the endless litigation problem. It was a brilliant free market solution, but of course, the idiot socialists attacked it using the stupid ideas of antitrust and perfect competition. Because this was such a good idea, after Reagan, there was a limited ability to allow patent pools in things like Wi-Fi or IEEE 802.11. Finally, there's a legitimate question about whether the Patent Office is a regulatory agency, and therefore not allowed under the Constitution. One argument is that the Patent Office could fall under the necessary and proper clause of the Constitution, but I'm very reluctant to make that argument, since the necessary and proper clause has been used for all sorts of nefarious purposes, including the First National Bank, which by the way was not a central bank, but still was a crony socialist bank. The Patent Office is the equivalent of a county recorder for land in the states. So the argument could be it's not a regulatory agency because it doesn't fit the definition of a regulatory agency. Property rights are not regulation. All regulations are a violation of natural rights. They presume that you're guilty until proven innocent, which the Patent Office is not doing. It's just determining and recording proper property rights. I will say that we need a more balanced approach between copyrights, which are protections of artistic creations, and patents, which are protection of inventions. Since they are both human creations, the differences between the two make no sense. There's no examination of copyrights at all. Obtaining them is trivial. There are almost no requirements. They're rarely invalidated, whereas it costs a fortune to obtain a patent. And patents only last 20 years from the date of filing, while copyrights are the life of the author plus 70 years. By the way, patents are only enforceable after they're issued. So therefore, they have a much shorter term than copyrights. I think that they should have roughly the same term length. I don't think we can get rid of examinations for patents, but we have to do something that increases the speed and lowers the cost of obtaining a patent, which I think can be done by having clear standards and also by using technology or outsourcing. This, of course, is a huge subject. I've just outlined some of the most important points in order to create a proper patent system. That is one that provides proper property rights for invention, which is necessary for freedom and economic progress. Because every bit of increase in per capita income and wealth in the world was the result of increases in our level of technology. The only way to increase our level of technology is by inventing new things. Long live freedom, damn it.